Members, it's the appointed time. We have a quorum. I call to order the meeting of the Bills Committee. I will now ask the Legislative Secretariat staff members to invite representatives of the administration to come inside the conference room. For the Bill, Import and Export Amendment Bill 2025, would members please refer to the specific papers on the LegCo website, including a LegCo brief issued by the Commerce and Economic Development Bureau, file reference CEDB/148/2/6. There's also a Legal Service Division report on the bill, LC paper number LS36/2025. We also have a background brief prepared by the LegCo Secretariat, LC paper number CB/2760/2025-02. Before we go into actual discussions of the bill, I would like to ask members, are we going to invite written submissions from the public and or deputations, or are we going to hold a public hearing? If we only require public submissions, written submissions from the public, the LegCo Secretariat will post a notice on the LegCo website and the district councils will be notified as per usual. So members, are we going to invite written submissions only? Right. Okay. Moving on. We are now going to discuss policy matters on the bill. I will now ask Mr. Andy Lam, Deputy Secretary for Commerce and Economic Development, to brief members on the bill. Members who wish to speak, please press the request to speak button. Thank you. Please, Mr. Andy Lam. Thank you, Chair. We are going to brief members on the Import and Export Amendment Bill 2025 to take forward the implementation of Phase 3 of the Trade Single Window TSW system. We are moving on at full steam to provide a one-stop electronic platform for the trading community to lodge business-to-government trade documents for trade declaration and cargo clearance. The TSW is being implemented in 3 phases. Phase 1 and Phase 2 of the TSW have been in full service since 2020 and 2023. While Phase 3 is the final and most complex phase of the TSW, it involves a large volume of documents submitted by a wide range of stakeholders. And it covers many different parts of the process. We are moving at full steam. The target is to roll out the Phase 3 services by batches from 2026 onwards. At present, the GETS, Government Electronic Trading Services, is the only electronic platform for the submission of the relevant documents such as the Import and Export Declarations, TDEC, Cargo Manifest, and applications for Certificates of Origin, CO, and Dutiable Commodities Permit, DCP. To implement Phase 3 of the TSW, we need to make amendments to the relevant ordinances and certain pieces of subsidiary legislation to replace existing systems by the TSW for submission of those documents. We will also make necessary legislative amendments to enable the provision of some of the Phase 3 services, including introducing a regulatory framework for value-added service providers, VASPs, so that the Customs and Excise Department can accept the submission and verification of trade documents and cargo information by the traders. And there is also a formulation of a set of predetermined vetting criteria to facilitate future vetting and approval of such applications. And in future, we are trying to accommodate electronic submission of the relevant documents. We will also allow for using the Trade Single Window system for the submission of documents to the Trade and Industry Department. Lastly, we will provide a legislative framework for the TSW. We also have some transitional provisions to allow the simultaneous running of the GETS as well as the TSW to facilitate transition of the trading community. We have set up 6 user consultation groups to find out about the views of the stakeholders. There is general support of stakeholders of the TSW, and last year we consulted the panel on commerce, industry, innovation, and technology, and we have also received general support from members. The Customs and Excise Department, in preparation of this, will make sure to have publicity and education initiatives to facilitate the use of TSW by the trading community. I urge members to support the bill and to pass the bill as soon as possible to facilitate the implementation of TSW next year. Thank you. The speaker's microphone is not on. 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 Dr. John Eaton. Thank you, Chair. I very much welcome the amendments to be made to the Import and Export Ordinance. For Phase 3 of the TSW, it is very important for Hong Kong's maintenance of the status of International Logistics Center. And as said by the administration, Phase 1 and Phase 2 of TSW have been commissioned since 2020 and 2023, and the system has received support from the trading community. We have recently faced unfair treatment from the U.S., such as the imposition of tariffs on different parts of the world, including our country. I think we need not worry. We just need to do well on our own. I think with the legislative amendments, it would help enhance our infrastructure. I have some questions on the policy issues. One of them is on the fees. For Phase 1 and Phase 2, the services are available for free to attract stakeholders to get on board. And according to the paper, the services will be charged on a cost recovery basis. And I understand that this has cost over $1 billion, so it may not be that we can charge low fees in order to recover the costs. In regard to the specific circumstances, the difficulties faced by the trading community, will the administration charge lower fees to help the trade tide over the gap? Now, the TSW is not a single function system. It provides many different services, value-added services. It also provides interfacing to certain systems, such as systems in the mainland. And I understand that the administration has been discussing with the ASEAN to promote interfacing of the single windows of Hong Kong and the ASEAN. I want to ask about the latest progress of the discussions, and does the administration have any plans to have interfacing with other systems, as the chief executive is going to have more delegation visits to different parts of the world? I also want to ask about manpower. For Phase 3 of the TSW, we will have a significant increase. We will have approximately 130 million documents to be dealt with. Will the Customs and Excise Department have enough manpower, especially when there is going to be a period in which there is simultaneous running of the GETS as well as the TSW? Thank you. 3 questions. Deputy Secretary. Thank you. First, on the fee levels, we will make sure to consider the affordability of the trading community. Of course, we are trying to recover the costs as well. We are talking about the operating costs. We are not talking about the capital expenditure. As you know, there was a significant capital investment into the system. When we're talking about operating on a cost recovery basis, it's just to recover the operating costs. And we believe the fees will not be that high as a result of that. It will not be far from other electronic submission fees of government services. This is what we're going to do in the first stage, and in the second stage we will try to make sure we can allocate manpower efficiently to compress the costs. As said, we are investing not only in the system, we also need to invest in terms of manpower costs, but we are trying to compress manpower costs as best as we can. We will make sure the fees are going to be acceptable to the trading community. There is something else that I want to say. For the legislative proposals, one of the things we're going to do is to introduce pre-shipment submission of trade documents. We have for the TDEC import and export declarations and other manifests, they are to submit such documents within 14 days to trade. And we will engage the trade on a voluntary basis, and if they submit such, we will make sure the fees will be lower for those who submit early. As for the fee ASPs, as well as interfacing with other jurisdictions, we have only just commenced discussions with the ASEAN, and we've received quite positive feedback. But let me say this, the ASEAN consists of 10 economies, and for the interfacing of all 10 economies, whether it is technically feasible, we need to really explore that. We will continue to liaise with the ASEAN to see how we can interface with them. Can we interface them on a group basis, or do we need to interface with each economy specifically? As for outside the ASEAN, in other parts of the world, we have major trading partners, of course, that would be the mainland as well as the ASEAN countries. So we will focus on the mainland as well as ASEAN member states first before we expand the interfacing to other trading partners. It will perhaps be what we're going to do at the next stage. As for manpower, the Customs and Excise Department would need to deploy suitable manpower for the implementation of the TSW. Phase 3, the major difference is that for the government as well as the trade, we right now have 3 companies operating GETS, GETS, and in future, TSW. No matter how much we're going digital, we will still need some manpower from the Customs and Excise Department to operate the TSW, and the Customs and Excise Department is still fleshing out the plans for deployment. As you know, we're faced with a tight fiscal position. We try to deploy manpower as much as possible internally. Unfortunately, if we need additional resources, we will try to, as much as possible, deploy such internally. Thank you, Mr. Frankie.
Thank you, Chair. For TSW, Well, this has been demanded by the logistics and transport sector for a long time, and ultimately the government is willing to take it up, and we welcome that. And the trade has all been very supportive of the initiative. But what we've been criticizing is that it has dragged on for too long, and we hope that this final stage can be implemented as soon as possible. My first question. In the background brief of the LegCo, you mentioned, well, in paragraph 22, that you would be interfacing with other TSWs and commercial systems. My question is similar to Dr. Johnny Ng's. Let me make it clear. There seems to be 3 levels of interfacing, and that is my company. If I have a system which can be connected to your system, then that can facilitate the electronic transmission of trade documents. And the second level is that connection with public facilities like piers, airports, and cargo terminals. And the third level is interfacing with overseas TSWs. Is my understanding correct? There are 3 levels of interfacing. Second question. And in another paragraph, paragraph 36, you mentioned that in phase 3, there will be a new and highly automated cargo risk assessment engine that will be established that will enable CNED to screen cargo information more efficiently. To my understanding, the CNED now has some similar system like the big data analytics system. So how is it different going to be in the future? I know that CNED is doing it now. Their intelligence gathering capability is very good in detecting illegal activities. How is it different? I mean, the new system, how is it different? And the third point, I agree with what Dr. Johnny Ng said. Going forward, I hope that users should pay as minimal amount as possible. And you mentioned that you will be reviewing your internal operations. Well, not only that, you should also be ascertaining how the trade is handling the different documents. You have to know about their internal costs. You should not be mindful about your own costs. You should also be looking at my costs to make sure that we find your systems more affordable. And then you also mentioned about 3 companies providing the relevant services, and then you would consolidate the services, and then one company will handle it. And theoretically, the costs will go down because you are replacing 3 by 1. So the costs should be cheaper. And I agree with you that if users can do pre-shipment declaration, there would be concessions in the costs to incentivize to switch from post-declaration to pre-declaration. I support that. From the risk control point of view, I hope that everyone will be resorting to pre-declaration. But then the trade has been emphasizing that is one of our competitive edge, and we don't want to see it being cancelled. But I hope that you can provide more incentives to attract them to use the pre-declaration approach. Undersecretary, thank you very much for your question. In response to your first question, connectivity is at 3 levels. Yes. Right now, the system is designed in a way that we would facilitate people who are in a big company and they have a lot of documents to submit to the trade single windows. So if they can connect their system to our system, that would be good. That's feasible. On the second level, connecting with peers and other public facilities, we would be looking at what purposes it serves. If additional information can be provided which is conducive to your operation, so we will do that. And maybe Mr. Yik might have heard from the Transport and Logistics Bureau that we are already looking at the relevant arrangements. Earlier, the TLB has come to the LegCo and said that they will talk with the CEDB on how their systems can be connected to our systems, and the work is ongoing. So member can rest assured. And then third question is about risk management. A new system should be better in terms of its capability when it comes to risk management. That should be an improvement from the existing system. Can I defer to Ms. Young from the CNED to elaborate? Ms. Young. Thank you, member, for your question. While Hong Kong is using different cargo systems to handle different cargoes from different transport modes, for the new system, we would adopt a standard centralized approach in managing risk. So in the same system, we can grasp at different information. Say, for example, the information from carriers, forwarders. So all this information will be stored in one system, and which can enhance our efficiency in cargo clearance, risk management, etc. And in the new system, we will be using AI and big data analytics on a massive scale to do risk management, and hope that we can check the cargo more effectively and do risk management more efficiently. And our manpower will then be centered on high-risk cargoes, and the work can be more accurate and efficient. So we hope that the system can help with our risk management work, and we can also expedite the cargo clearance period. Costs. Chair. We can achieve synergy, theoretically, because after all, we are talking about massive volume of documents. If the government is taking over the work from 3 companies and we're using one single system, we should be able to achieve synergy. But anyway, costs are involved because we are talking a voluminous amount of documents. And the front line, the front end office used to be GATS, and now we are also taking up both the front end and back end work. So some costs may have to be involved because the government is taking over the work from 3 companies. We envisage that the costs to the companies will not be very different from that of today. I hope that you can also try to understand what costs and what resources are involved on the part of the trade now. And you should do some comparison between what is happening now and what is going to happen in the future. Oh, okay, first round is my turn to ask questions. The TSW is very important to Hong Kong. Hong Kong's trade is in a transformation stage, and we should move even faster in terms of digitalizing our work. Now, we are talking about several phases of work, but you are not mandating certain workflow of operations, and you're not making it mandatory for the stakeholders and the trade to take part. Great investment is involved in developing the system, and we hope that the investment can benefit the trade and the import and export trade sector. And many SMEs are not very familiar with such electronic platforms, and you said that you adopt a voluntary approach. And I envisage that for a long period, only the big companies will take part and use the service, and SMEs will maintain their status quo. And why is not the government mandating everyone to use the system? Now, different trade systems are being developed and used by different countries. In the last policy address, the CE said that and many government fees can be paid online in the future. And TSW is championed by CEDB, and the CNED will play a vital role in the future. And for, say, the tariff imposed by the CNED, like those on tobacco products and alcohol, we also make use of this platform to collect such fees. Can users pay such tariffs on this platform? Would you consider that? Thank you, Chair. On whether we should mandate users to use the system. When we talk about TDEC, cargo manifests, and certificates of origin, and dutiable commodities permits, well, these are being handled by another electronic system. And for phase 3, we are trying to transit the operations on such old systems onto the new system. And for the road the road cargo manifest, we will be transiting to an electronic format. And we hope that the relevant documents can be fully digitalized in the future. We have not set a timetable. We hope to allow enough time for the trade to adapt. And on the mainland, we know that electronic road cargo manifests are being used, and I believe that the sector has also already acquired certain capability in that area, and it won't take them long to adapt to the new system in Hong Kong. And we hope that when the two systems have been running in parallel for some time, and upon the consent or the agreement of the trade, we would cancel the paper form in due course. And the Commission of CNE can specify a certain date on which the paper form will be cancelled. How can we incentivize the users to use the electronic format? How can we encourage pre-shipment declaration? I hope that our value-added service providers can do something to encourage SMEs to switch to electronic format. The SMEs may not have a lot of documents to handle, so we hope that the VASPs can do more to help them. As for collection of fee, our electronic platform has the capability to allow users to pay the fees in relation to the issuance of the DCPs. So in our design, such function has already been incorporated. Second round, Dr. Johnny, 5 minutes. Thank you, Chair. I'd like to raise a question on some technical issues. The TSW is a very big system, and different government departments have launched different big systems, and they have faced challenges as reported in the media. And we envisage that there will be difficulties because we're talking about transiting from some old systems to a new system. First, on security arrangements and security considerations. We just passed the bill on the computer system on key infrastructures, and the government said that it will adopt an even high security standard for this big system, the new system. So what will you do that to ensure that the system will be free from outside cyber attacks? Will there be a situation where there will be a suspension of supply of hardware and software from outside, thus suspending the operation of our system?
Next, right now we have for the GETS3 operators. Will they participate in future as VASPs or what? I mean, they have served the community for many years. I believe they should have some know-how we can tap into. Can they help in some way in future? That's my second question. Thirdly, on training, the Customs and Excise Department will play a part in the transition. The biggest problem with transition between an old system and a new system is to build new habits for users, and this is, of course, a challenge. What are the specific plans of the Customs and Excise Department for transition? I think a key to success would be to make sure users can actually transition seamlessly. We also talked about big data analytics. I know the Customs and Excise Department will assess the relevant risks, but can the CEDB play a part to see how we can make use of the data collected to better identify, say, areas of demand? And then you can disseminate such information to exporters, manufacturers, SMEs in general for their business development. I believe these data would have great potential. Would you do something in extracting such market data to help with the enterprises business? Thank you. Deputy Secretary, I'll perhaps answer the last question first. We do note the Hong Kong Monetary Authority has held a meeting with the Transport Logistics Bureau on Cargo X. It is a working group. And the HKMA is working with the TLB to see how they can make use of data to help enterprises. Outside of Cargo X, however, the CEDB has already been working with the Hong Kong MA to make use of data obtained through the TSW. Basically, the Hong Kong MA has something called the Commercial Data Interchange CDI in Phase 3 of the TSW. After commissioning of Phase 3, there will be interfacing with the CDI. And with data obtained through the submission of trade declarations, the data will be used in trade financing. We will continue to liaise with the Hong Kong MA to make sure CDI can make use of the data within the TSW for development of trade financing. On computer system security, the government does attach great importance to that. Every time I host a meeting, I make sure to work with the operators on this. We also have in attendance representatives from the Digital Policy Office to make sure we are vigilant against risks. And we'll make sure the system conforms to the security requirements of government services to make sure the relevant system, even during development cycle, would conform to the relevant requirements. We also have multiple levels of safeguards against attacks and unauthorized access of data. For enterprises connecting to the TSW with their own systems through interfacing, they must conduct prior registration. They also need to comply with the relevant implementation instructions when interfacing with the TSW. They need to implement security measures. They also need to conduct system testing before they can have their systems interface with the TSW. This is to ensure security of the TSW. And on transmission of information, we will also implement measures to protect data. In transmission as well as storage, we will make sure to adopt world-class advanced standards to ensure security of data. We will make sure to use TLS. We will also make use of public key infrastructure and AES encryption standards to make sure we have adequate protection of data. As for the 3 current operators of GATS, what role they are going to play in future. In future, these operators will become VASPs, and we want to develop the market for VASPs so that there will be in future more companies that will be able to provide value-added services that should enhance competitiveness of the industry. We can also see that this will in future lower the relevant costs. I believe these will better meet the demands of the trading community in the future. For the TSW, the Customs and Excise Department is working hard to prepare for the implementation of Phase 3. We have to make sure as much as possible the transition is seamless. It would be best if users don't really feel that much of a difference using the new system, but inevitably there are going to be new features with the new system. We want to make sure we can teach new users how to use such features, and one of them is, as said earlier, to facilitate pre-shipment declarations. We want to, of course, compress the submission time needed for parties. If the chairman would allow it, I will ask Ms. Yuan Wing Yan from the Customs and Excise Department to supplement my answers. Please, Ms. Young. To facilitate users to make use of the new system, we have been enhancing our publicity and education efforts. We have various initiatives. We have some ads. We have also held some large-scale seminars. We also have mobile vehicles and stations for promoting the system. We are not only targeting the trade for this. For efforts that target the trade specifically, we have made visits to certain enterprises to hold tailored training sessions for the enterprises so that they can be on board relatively smoothly. We are making the relevant preparations. Thank you. Mr. Frankie Yick. As the Deputy Secretary said, when we were approving the funding for the PCS Port Community System at the Finance Committee, we asked for the trade single window system to be interfaced with the port community system to leverage on the relevant advantages. As Dr. Johnny said, what kind of data can be published for enterprises' reference is key. If we can make use of data to develop new business, that is definitely appreciated. So I want to ask, would you be able to make available to the public some of the data of the trade single window in future? As for interfacing, we will be interfacing with other jurisdictions. And I remember about a decade ago when we were calling for trade single window to be implemented in Hong Kong. Back then, there was no such system in the mainland, but there was already one that has been implemented for quite some time in Singapore. And recently, a visit was made to Kazakhstan, and Singapore was promoting their trade single window system in Kazakhstan. They are moving fast. I understand that you have been liaising with the ASEAN and you have received positive feedback. So I want to ask, do they actually have a TSW system already, or do we need to help them set up a system and then we can interface with them? What is happening? Thank you. Deputy Secretary, on the PCS, we will of course work with the Transport and Logistics Bureau to discuss how we can interface the two systems. But we need to find out more about the use cases before we can determine on what data are to be shared. As for what data are to be made available to the public or enterprises, in future, electronic government services and the trade single window, they focus mainly on the submission of trade documents and cargo manifests. And there is also the certificates of origin as well as the DCP's dutiable commodities permits. I think in the end, the Census and Statistics Department will be publishing figures of the TSW at some point. So these will, of course, be made available to the public. As for real-time publishing of information for enterprises' reference, for them to know the latest situation, what can we do in this regard? I believe we need some time to explore that, to see how quickly we can update the relevant data for sharing. I believe we need to work with other departments on this, and unfortunately I can't provide a concrete answer today. We will, however, try our best to facilitate the use of such data by industries. Data are very important these days. We do understand that. We will try to, as much as possible, allow industries to leverage on such data. As for interfacing, for ASEAN member states, they are at different stages in implementation of TSW. The country, Singapore, has of course been implementing TSW for some time, as the member said, but for other member states, they may not be as advanced. It's just like what is happening in the EU. They are at different stages, and if we are to interface with individual systems of the member states of the ASEAN, it may take some time. We don't expect to set up TSWs for the specific member states if they do not even have a TSW at the moment. We just want to make sure there is meaningful connectivity in some way with ASEAN member states. Thank you. Any other questions from members? Ms. Judy Chen, please. Thank you, Chair. I would first like to express my support for the TSW. To develop the 8 centers in Hong Kong, one of the important initiatives is to make sure we develop our international trade center positioning, and that should have a long-term impact on the economy of Hong Kong. I want to follow up on what Mr. Frankie Yik said or asked about data sharing. You said you are not able to provide a concrete answer today. You will explore this, but I hope that we can do some more. According to paragraph 7 of the LegCo brief, it is said that you would be charging the trading community some fees for using the services, and I believe data are important to industries these days. There may be general data such as the exports or during what times of the year there would be higher exports. They are, of course, useful to a certain extent, but I think you should do more in having more analyzed data, and then you can sell such data to enterprises because they will be valuable. And I think when we scrutinize the bill, if we are already exploring this, I believe it can definitely help us with recovering the costs for operating the system. And in turn, it may actually lower the fees for the trading community. That can be beneficial to the industries as well. I think you should actively explore this. Thank you.
Under Secretary, any response? Thank you, Ms. Chen, for your comment. We will actively look into that. Thank you. Any other member who wishes to ask a question? If not, then we will go to clause-by-clause scrutiny of the bill. Members, please note that the legal advisor on the 28th of April has written to the administration on the drafting of the bill, and the paper number is CB 2784/2025 and bracket 01. And the administration will give a written reply to this letter. And during the clause-by-clause scrutiny, please, would legal advisor please raise legal issue, drafting issues, and member wishing to ask a question, please press the button to request to speak. And then let's first scrutinize the Chinese version of the bill. And if members have any questions relating to the English version of the bill, okay, please refer to LC paper number CB bracket 2517/2025, the long title and the sections Clause 1 and Clause 2. And can the administration representatives please brief us on the bill? And after the scrutiny, please refer to the marked up copy prepared by the Secretariat, CB bracket 2760/2025 bracket 01. And can the administration explain the clauses one by one? And if necessary, the administration can respond to members' questions in a written format if necessary. After the Chinese version has been scrutinized, can the legal advisor please advise whether the English version is proper? So, Under Secretary, please. Can I ask Ms. Selina Mack, Principal Assistant Secretary for Commerce and Economic Development, to brief us on the different clauses? Selina. Good morning, members and Chairman. The long title. A bill to amend the import and export ordinance related legislation to provide for the use of the trade single window system for transmitting certain import and export related information, to provide for offences relating to the use of the system, to allow pre-shipment submission of certain declarations and benefits, and to make related to miscellaneous amendments. Part 1 preliminary. Clause 1. Short title, the ordinance may be cited as the Import and Export Amendment Ordinance 2025. Subject to subsection 3, this ordinance comes into operation on the day on which it is published in the Gazette. The following provisions come into operation on the day to be appointed by the Commissioner of Customs and Excise by notice published in the Gazette. And most of them have to do with the services provided by the service providers in undergets. We have to retain their status so that they can continue to provide services under gas. So these provisions will only be repealed or come into operation after the gas system has been cancelled. And the Gazette the notice will be in the form of subsidiary legislation to be vetted by the Legislative. Clause 2, the annex specified in parts 2 to 9 are amended as set out in those parts. Let's move on to part 2, the interpretation. We would like to make some amendments. Right now, the INO section 2 provides interpretation definitions of under gas security device services provided by a specified body, specified agent, specified body. So these will not be applicable after gas has been cancelled. So we repeal the definitions, and they will come into operation by notice in a Gazette set out by the Commissioner. And we will add in some new definitions. Towards the end of the interpretation section, there will be some new definitions, including specified system means an information system specified in Schedule 4, and under Schedule 4, information system has meaning given by Schedule 4, has the meaning given by Section 2, Bracket 1 of the Electronic Transactions Ordinance, Cap 553. So means the TSW complies with the definition under the Electronic Transaction Ordinance. We would also add in a new definition of transmit in relation to any information, includes send, deliver, give, lodge, submit, and furnish the information. This is used mainly for used by the value-added service providers to meet with their operational needs. There will also be a technical amendment, and that is all the definitions related to gas. The specified system will replace the term specified body. And under Clause 2, we have a license of a definition. And the license the technical amendment will be made to substitute the services provided by specified with the specified system. And the lodging of security, the definition of security device, etc., are related to the use of gas. We will repeal these systems, and they will come into operation a day to be appointed by the Commissioner of Customs and Excise by notice published in the Gazette. And for Clause 3, there is also Ms. Judy Chan, you have a question, is that right? Yes. Can I go back to the definition of transmit? Because in the Chinese and English definitions, it means furnish the information. Well, normally we'd say that provide, but then in the English rendition, the term furnish is used. Is it because the trade has been using the term furnish, or is there any other special consideration? Under the INE ordinance, you are already using the term furnish. The spirit behind is that we would be using terms already used under the existing INEO. Or the term provide sounds more straightforward and more comprehensible. Well, in the legal sector, the term furnished is often used, and it has a similar meaning as provide. How can the Government Council, please? Thank you, Member, for your question. On the term furnish, under Cap 60, this term has been in use. We would like to cover acts which which have the meaning of sending, deliver, and so on. So we would like to use a single term to express these different meanings. We don't intend to amend terms which are already in use under the existing INEO. And the term furnish is already in use in the present legislation. That we do not deliberately amend such terms. And so we are adding in new terms to cover all these acts. Thank you, Vincent. And thank you, Selina. And clause 3, this is also a technical amendment. And well, we are substituting specified system with services provided by specified body. And Section 6AA, well, there are provisions relating to the import and export of textiles under the present legislation, and the licenses related to the import and export of textiles and well, the relevant licenses have been cancelled after a certain time, but then the provisions are still in use. So, and in 6AA1, 6AA4, and 6AB2B, and 6AB bracket 3 and 6AD bracket 4C. And the relevant provisions are not applicable to the trade single window. We are making some technical amendments, and the director can, by publishing a notice in the Gazette, can repeal the using services provided by specified body. And we would add in a clause saying that these are not subsidiary legislation. And these are really to preserve the existing legal framework and cancel provisions related to GETS. And the TID is also examining under the provisions related to textiles under the INEO, and whether we should repeal these outdated provisions. And if needed, the TID will introduce further amendments if needed in the future. And Section 7, and from Section 7 to 11, these are related to delivery of prohibited articles, and the carriers should not release or accept prohibited until somebody presents the relevant license to him, and the carrier must also deliver the relevant licenses to the TID after the import and export. And the TID should also examine the relevant manifests to make sure that these are in compliance with the relevant cargoes and the details are fit and proper. And the license holder will present the carrier of the license in paper form, and the paper form license will also be delivered to the TID at the Hong Kong airport or the boundary control point. So we will be amending the legislation that on top of the existing arrangement, we will allow the license holders and the carriers to use an electronic format to present the licenses. So we would be added in 1A, 2, and B. So the commissioner gives to the conveyance owner written directions in will be respect of the removal or storage of the prohibited article. And Section 8 says that the license holder can deliver the carrier in different approaches. Apart from paper format, you can use the TSW to send the electronic license to the carrier so that the carrier can use the TSW to obtain the license.
In 2B, it says that 7 days after obtaining the relevant license, the license should be submitted to the TRD or notify the director in some way. And the relevant manifest should also be submitted to the director of the trade and industry. And essentially, it works the same as what it is right now, only it is in paperless form. For Mr. Frankie Yik, I want to ask about Section 7. Mainly, we have added more information. We only said with another term, conveyance owner. Now it says conveyance owner. Why? Well, with conveyance owner, it is a label instead of just owner of a vessel, aircraft, or vehicle, and it just refers specifically still to owner of the vessel, aircraft, or vehicle. We just want to have a shorter term for ease of reference in future, instead of just repeating the whole expression owner of the vessel, aircraft, or vehicle. For conveyance owner, it actually works the same way as what it did before. Alright, please proceed, Selena. Thank you. We're now at subsection 2A. The conveyance owner is taken to have complied with the requirement of delivering the license or informing the director of the license number. The manifest has been lodged using specified system with the commissioner or with an officer appointed by the commissioner. They don't need to submit another manifest, and it works roughly the same way as what it does at the moment as subsection 2A. Excuse me, can you go, when you do the clause-by-clause examination, can you also refer to the marked-up copy? Thank you. We're now at page 21 of the marked-up copy in Chinese, section 9. It is a technical amendment. We are substituting services provided by a specified body with the specified system. Let's move on to section 10, page 23 of marked-up copy in Chinese. We are amending section 10 to allow carriers to obtain an export license with the specified system. Page 24 of the marked-up copy in Chinese, section 11. The amendment is similar to that made to section 8. We are allowing an owner to deliver the license to the conveyance owner, essentially accommodating the use of the specified system. And within 14 days, the conveyance owner must deliver the license to the director in using the specified system to inform the director of the license number, as well as deliver a copy or extract of the manifest to the director. The conveyance owner, if they use the specified system to deliver the manifest, they would be regarded as having met the requirement under subsection 2B. They do not need to submit a paper form manifest. And it works roughly the same way as the existing subsection 2A. Next, section 15, page 26 of the marked-up copy in Chinese. This is another technical amendment. So say section 15, 1BC will repeal services provided by a specified body and substitute the expression with the specified system. Next, page 28 of the marked-up copy in Chinese it's Section 20. We are amending Section 21CIA. We are again repealing the part services provided by a specified body and substitute it with a specified system. Next. Page 32 of the marked up copy in Chinese. Starting from that page, we will have Part 6A, some new provisions. Part 6A would cover Sections 30A to Section 30F. It is a regulatory framework for transmission of information by value-added service providers. In Section 30A, it is interpretation. We have definitions for specified information, practice guidelines, and value-added service providers. Section 30B, page 33 of marked copy in Chinese. Commissioner may issue practice guidelines, and the commissioner may specify certain practice guidelines and amend or revoke them if necessary. The commissioner may specify in the practice guidelines the manner in which an application is to be made, the specific matters the commissioner may have regard to, and the standard at which a value-added service provider is expected to provide its services. And the commissioner must publish the practice guidelines as well as to make copies of the practice guidelines available to the public. Dr. Johnny, I want to ask about the definitions, specifically the definition for the value-added service provider. It means a company approved under a section to transmit on behalf of another person any specified information using the specified system. I want to ask, does it have to be another person? Can it be, say, another machine? Deputy Secretary. Well, when we talk about another person, we are talking about a natural person or a company, a body corporate, because it has to be another entity. It may be a sole proprietor or an other company. If you are a trader or a courier or forwarder, you are providing information on the TSW, submitting the trade documents. It would be originally the company's work, and then the value-added service provider would come in if they are engaged to provide such services. So say for a courier company, the consignor would be filling in information on behalf of the company, essentially. So it can be a natural person or a body. When you're talking about another person, it can represent a company, right? Or a body corporate. I'll let the DOJ colleague answer that question. Indeed, in interpretation and general clauses ordinance, we defined person to include body corporates or public bodies. So another person would cover other entities, not just natural persons. All right, please move on. We are now on page 34 of the marked copy in Chinese section 30. See, only value-added service providers may transmit information, specified information using specified system on behalf of other persons. And the value-added service provider must have the other person's written authorization for doing so. A person who contravenes the relevant subsections would commit an offense and is liable on conviction to a fine at level 3. These are on par with the penalties of similar provisions that do not have the relevant parties having written authorization but acting on behalf of another person. I believe the legal advisor would like to say something. I want to talk about for the issuance of practice guidelines. These are not subsidiary legislation, so they are not subject to negative vetting of the council. I would like to ask the administration to explain why this approach is taken And Ms. Selena Mack also talked about for Section 30C, the offense relating to transmission of information by value-added service providers. I also asked the administration to explain to members whether these offenses are strict liability offenses. That is, there is no need to prove criminal intent by the prosecution. If these offenses are strict liability offenses, would the common law defense of honest and reasonable mistaken belief come into play? Thank you. Thank you. We actually received the legal advisor's letter yesterday. We do know the issue raised by the legal advisor on whether these offenses are strict liability offenses and whether the common law defense would be available. We are currently liaising with the DOJ, and we will explain our stance in a written response in future. As for the practice guidelines, why they are not subsidiary legislation, I think we need to first think about whom we are regulating specifically. We want to make sure there is flexibility. We are regulating enterprises that are going to be value-added service providers in future, and there are actually no laws specifically to regulate their operations. And so far, it has been working fine for banks or other companies or courier companies. They have been working fine. If we are to regulate them in future, I believe we need to have in mind we need to achieve the policy goals of providing the services while affording flexibility to enterprises, also allowing the service providers to provide services that can meet the needs of the enterprise as well. We think there is no need to have practice guidelines as subsidiary legislation. We have 600 odd pieces of legislation in Hong Kong, and we actually have in many different laws, we would only have practice guidelines that are administrative in nature. And I believe our team has referred to the practices of the Customs and Excise Department. We believe the issuance of practice guidelines would be enough to regulate the trade. The practice guidelines will be made available to the trade, of course, and they will also be posted on the relevant website for reference. We believe this approach would offer flexibility, so we consider this approach to be appropriate. Mr. Frankie Yik, I want to follow up on an issue, specifically the issue of practice guidelines. In future, the value-added service providers follow the practice guidelines, right? But if they don't follow these guidelines, can their authorizations as VASPs be revoked by the Commissioner for Customs and Excise? That is possible, but the Commissioner will be prudent when exercising this power. And as I said earlier, the traders are working fine right now, even without legal regulation at the moment. We just want to make sure they provide great services to their clients. With practice guidelines in future, I think we can even do more with this flexibility. Say, right now, we have only post declarations. We hope that VSPs can help us enhance awareness so as to encourage enterprises to lodge pre-shipment declarations in future. We believe the flexibility is actually beneficial. As for whether we'll revoke authorizations for VASPs, if we see malicious cases in which VASPs submit misleading information voluntarily multiple times, then we may revoke the relevant authorization, but we do not anticipate that happening a lot. Mr. Frankie.
That's been a recent case. This service provided, according to the forwarder's information, and he submits and delivers the information to the government. And if the forwarder is providing the wrong information and the service provider inputs the same information, is he held liable? Because that has been a recent case. Somebody has been smuggling, and under the present legislation, the truck driver is also held liable. And he has a duty to check whether the goods are proper and legal. But it's difficult to do so because everything has been wrapped up and you cannot unwrap the cargo to make the checks. But then the legal provisions state that the truck driver does have the responsibility. How are we going to deal with that? Say if the service provider deliberately misleads the CNED, he is to be held responsible. But then if the wrong information is fed to him, does the value added service provider have the responsibility? I believe that in the future, the practice guidelines should contain some templates. Say there should be a template for the contract between the forwarder and the value-added service providers, because after all, the letter is an agent. I hope that you can set out clearly the relationship among the different parties. I think the chairman's suggestion is very good. We would look at how our practice guidelines should facilitate the carriers in doing their work. And some of the things are definitely going to be put in the practice guidelines. There should be clear delegation of authority. But as to whether there should be a template, and we would look into that to see how much guidelines that we should put into the paper. And then for Mr. Yik's suggestion, we would be looking at the evidence of each individual case. It's difficult to tell sometimes if the carrier has reasonable grounds to believe that the cargoes are not in order and are not taking reasonable steps to check the cargoes, well, he should be held liable. I cannot comment on individual cases as to whether the case you mentioned, the carrier should be liable or not. We have to look in each and every case individually. So we would be looking at the individual circumstances before ascertaining the liability or responsibility. Well, my trade is very concerned. And it's difficult to find somebody to drive the car because the driver may be held criminally liable. He should be responsible for checking the cargo. It's practically impossible to check the cargoes because the goods have been properly wrapped or packed. So, of course, this is an old piece of legislation. I hope that you can study into it because the trade has been expressing concern to me, and they said that it would be difficult to recruit drivers in the future. Mr. Yik is right in pointing out the case. This is not a case which arises out of the legislation or the bill that we are handling today. Mr. Yik may find my answer not satisfactory, But after all, we have to look at the circumstances of each individual case. But the legal principle you mentioned is right. We would relay or convey your opinion to the relevant colleagues. Selina, please continue. 30D, page 34 in the Chinese version. Application to be approved as value-added service providers. Subsection 4. On granting an approval, the Commissioner may impose terms or conditions on the approval that the Commissioner considers appropriate. And legal advisor has a follow-up. Thank you, Chair. 30D, I have some following-up questions. Can the administration explain to the members? Applying to be a VASD, if the Commissioner refuses the application, should the Commissioner give reasons? And in subsection 1, if it says that a company that hosts a valid business registration certificate enshrined under the business registration ordinance may apply, what does the company cover? Is it cover those under Cap 62.2? Does it cover the legal person? 2 questions. On the second question, yes, it covers all sole proprietors and partnerships and other forms of company. As long as you hold a business registration, you can come forth and apply. Because these companies exist in different forms. They might not be incorporated companies. So the scope covered is quite wide. As to your first question, the legal advisor set out that question in your letter sent to us yesterday. We will give you a written reply. Okay, thank you. Selina, please continue. And 30E, the Commissioner's powers relating to value-added service providers' misconducts and the actions that he can take in brief to ensure that the value-added service providers are not engaged in any misconducts. The Commissioner has certain powers. The Commissioner may issue a warning letter to the provider to suspend or revoke the provider's approval, in forming an opinion on whether the service provider is appropriate for providing services. It can have regard to any matters that the Commissioner considers relevant, including whether the VASP has failed to comply with the practice guidelines. Legal advisor. On 30E, similarly, I'd like the administration to clarify, say, in revoking the provider's approval, should the Commissioner be providing reasons? Would there be an appeal mechanism for those affected by the decision to make an appeal? On the Secretary, we will give a detailed written response to the legal advisor's opinion. Well, let's set out some simple principles here. The legal advisors seem to be focusing on whether reasons to be given, whether there be an appeal mechanism. If we look at things from the perspective of administrative law, to my understanding, that there are 2 elements: right to be heard and duties to give reasons. And the administration understand the administrative laws requirements on the administration. I can say that we will not give any reasons, and whether there will be a mechanism for them to voice out their objection to our decision. Of course, they will be given a room to voice their opinions on our decision. As to whether a proper appeal mechanism will be established for them to lodge an appeals, I hope the legal advisor can give us more time for us to give a written response. That will make things more clear. Please appreciate that the administrative law does have a binding effect on the administration. Mr. Frankie Yick. Well, this is quite a sensitive issue. I understand that. It is difficult to, yes, give a specific reason for refusing the approval. So, or or rejecting the application rather. So I await your response. Selina, please continue. And page 36 in the Chinese version, 30F, is presumption regarding information transmitted by value-added service providing using specified system. We have taken reference from 2B2, and it says that the value-added service provider where the information was transmitted by a value-added service provider with that other person's written consent. A person named in the information in the absence of service to the country is to be regarded for the purpose of this ordinance as the person who made the statement or declaration. And 31, the chief executive and council may make regulations for all or any of the following papers and prescribing the fees to be collected by the commissioner or the manner for making such payment. It seeks to set out a legal framework for collecting the fees. We're looking at the operating cost of the CEDB, and before phase 3 is implemented, we will be setting out subsidiary legislation to set out the relevant fees. And if needed, we will also be making adjustment to the fees. 32A is also a technical amendment. So the terms services provided by a specified body will be replaced by specified system. 32B again is a technical amendment, specified system substituting services provided by a specified body. 33A on page 41 of the Chinese version again is a technical amendment, specified system replacing services provided by a specified body. And 36C and 36D, page 42, these two provisions relate to the existing guests and the offences under them. And 36C is offences relating to the use of keeping of a security device, and 36D are offences by specified agent. And these two provisions to come into operation on a date to be appointed by the Commissioner by way of a notice in the Gazette. And 39, the Commissioner of Customs and Excise may, by notice published in the Gazette, amend Schedule 4. And the Schedule 4 lists that the CEDB is the specified system, and the relevant notice is the subsidiary legislation and will be vetted by the LegCo by way of a negative vetting. Section 42. And the present transitional arrangements and the newly added Section 43 transitional and saving provisions for IEO, the specific arrangements for this. For the period specified in subsection 3A, a reference is specified provision to using the specified section is subject to any determination made under 32AAA or notice published under 35(2)B. And subsection 8, 9, and 10, the trade can use paper form and also TSW to submit the relevant cargo manifests. And the commissioner can, but by way of a notice in the Gazette upon a date when the legal provisions will be commencing into operate. And the subsection 6, a reference in Section 21 or using the specified includes a reference to using services provided by a specified body. And Schedule 2, specified body and specified agents. And after TSW come into operation, specified body and specified agents are will not be used, and these will be repealed, and they will be come into operation on a date to be gazetted by the Commissioner.
Page 49 of the marked-up copy in Chinese Schedule 4, we will add a Schedule 4 on the specified system, basically referring to the trade single window system. Next, Chapter 60A, that is Part 3 of this bill. For Regulation 2 of the Import and Export General Regulations, we have amended the definition of in electronic form. We have again repealed a part for services provided by a specified body and substituted it with the specified system. Next, Regulation 6A of Chapter 60A, as well as 6B, 6BA, and 6BB. We have made technical amendments. While they refer to services provided by a specified body, but TSW does not apply here, which is why instead of using the specified system, we are substituting it instead with in a manner specified by the Director by notice published in the Gazette. Alright. Page 56. 59 for Regulation 6C. Again, it is a technical amendment replacing services provided by a specified body with the expression specified system so that TSW would apply. Next, Regulation 6CA. We are adding a new Regulation 6CA, yes. Also on page 59 of the marked copy in Chinese, we are adding Regulation 6CA to say the notices referred to in earlier provisions are not subsidiary legislation. Moving on, page 60 of the marked copy in Chinese, Regulation 60AC and 60AE, they are delivery of transmitment notifications and manifests to the Director. We have said for carriers, they need to submit transmitment notifications and manifests to the Director of Trade and Industry. And in future, we are accommodating the option of submitting the transshipment notifications and notification of the specific notification numbers on the TSW. Alright, page 62 of the marked up copy in Chinese, Regulation 60AG, we're making a technical amendment replacing services provided by a specified body with the specified system. Moving on, page 63 of the marked up copy in Chinese, Regulation 60AH, we will repeal the regulation. These are transitional provisions. For Part 5B, we will add a new Regulation 60AI to promulgate new transitional arrangements. And it says specifically a reference in Regulation 60AC, 60AE, or 60AG. The trade may make use of the specified system or paper copies to submit the relevant documents. And the Commissioner may designate from a gazetted date for the relevant paper copies to be phased out. And this is subsidiary legislation, this notice. We will also add an Regulation 6J to promulgate transitional arrangements, a reference in Regulation 2 or 6C to using the specified system is to be construed as a reference to using services provided by a specified body to make sure we can continue to use gets the period specified as the period beginning on the Gazetted date and ending at midnight on the date to be appointed by the Commissioner of Customs and Excise. This notice is again subsidiary legislation. Next, Schedule 8, we are making technical amendments. Instead of using services provided by a specified body, we are using instead expressions in a manner specified by the Director by notice published in the Gazette. Alright, moving on. Chapter 60B. Page 79 of the marked copy in Chinese, Import and Export Fees Regulations. This is part 4 of the bill. It is about fees for submission and transmission of the relevant documents and information. We amend Regulation 2 for prescribed fees and manner of payment. And the Commissioner may prescribe some fees for the submission of documents as well as the application of, say, permits on the TSW. In the schedule, we have made multiple technical amendments to update the fee table. Say for item 4, we will simplify it to have only one item under item 4, and then we will also remove some outdated forms. Alright, next. Page 88 of the marked copy in Chinese, Chapter 60E, Import and Export Registration Regulations. In Regulations 4 and 5, we have amended the provisions relating to import-export declarations to accommodate for pre-shipment import and export declarations. We will allow for the lodgement of no later than 14 days after the date of importation or exportation of the article. We have also added the requirement to update pre-shipment declarations to make sure there is accurate declaration and complete declaration. If a person without reasonable excuse contravenes the relevant paragraphs, they commit an offense and is liable on conviction to a fine at level 3. Legal advisor. Well, as said by Ms. Selena Mack, they will accommodate pre-shipment import or export declarations. I want to ask what material particulars have to be provided in the declarations. If the persons do not update the relevant information to make the declarations accurate and complete, that will be an offense. Is that a strict liability offense? Also, on conviction to a fine, there will be a fine at level 3 that is $10,000. What is the administration's justifications for this level of fine? Thank you. Deputy Secretary. For the submission of manifests, they will have to declare the type of goods, the quantity, as well as the value. And these will be found in the manifests and declarations. Such information is important for the work of the government on not just data collection, but also in terms of enforcement. If the trader or the consignor knows that there is inaccurate information, they have the responsibility to notify the government of such. This is the current practice. If information is lodged later than 14 days, if they know something is inaccurate, the traders or consignors have the responsibility to notify the government of such as it is right now. This is an existing arrangement. As for the level 3 fine, $10,000, we have referred to the offense if one provides information post-shipment. If the information is inaccurate, the level of fine is the same. We will provide in our written response the answer to the question about strict liability offense, but basically it works the same way right now. Thank you. Selena, please proceed. Regulation 8, again a technical amendment. We will have implementation instructions for import-export declarations of the specified system replace the current guidelines, and the charge must be paid in manner specified by the Commissioner. Pages 94 and 96 of the marked up copy in Chinese Regulations 9 and 10, again technical amendments to replace services provided by a specified body with the specified system so that notifications can be issued through the TSW. Next, Regulation 11, page 99 of the marked up copy in Chinese. Import manifests. The amendments are similar to those before. So we have for pre-shipment import manifest, we will allow for VASP services to be engaged through the TSW, and the notifications must be lodged. Manifests must be lodged no later than 14 days after the day of importation. Also, updates must be made to the manifests to make the manifests accurate and complete for the risk assessment of the Customs and Excise Department. A person who, without reasonable excuse, contravenes paragraph 4A commits an offense and is liable on conviction to a fine at level 3. Alright, please proceed. Regulation 12A. Again, a technical amendment to replace services provided by a specified body with the specified system. Regulation 13A for security devices and Regulation 13B on specified agents. These regulations will be repealed, and these are to come into effect by notice published in the Gazette by the Commissioner. Regulation 14, again a technical amendment to replace services provided by a specified body with the specified system. Regulation 14A, this is a new regulation to specify for the offenses in the import and export ordinance a reasonable excuse defense, and the defense is raised when there is sufficient evidence adduced. That alone is enough. Next, Regulation 15. We will repeal the regulation on existing transitional arrangements, and we will add Regulation 18 on some new transitional arrangements, which are similar to the ones I mentioned before. Next, Part 6 of the bill. Chapter 60F, Import and Export Removal of Articles Regulations. We're amending Regulation 6, again, a technical amendment to replace services provided by a specified body with the specified system. Regulation 7. It is new to promulgate some transitional arrangements. A reference in Regulation 6 to using the specified system is to be construed as a reference to using services provided by a specified body to ensure the simultaneous running of gets. Alright, Chapter 60H, Regulation 6, amended, again a technical amendment to replace services provided by a specified body with the specified system. We will also add Regulation 14 for transitional arrangements, and this provision is just like the ones before. Lastly, Chapter 60L, page 113 of the motto copy in Chinese. We will repeal the definition of information system in section 2. It is because we already have a definition in the previous clause, so we will repeal this definition here. Clause 3. Alright, let's move on. Part 9 of the bill, related amendments, Chapter 1C, amendments to specification of public offices notice. To specify that there is power of delegation of the powers of the Commissioner of Customs and Excise. Next, amendments to Dutiable Commodities Ordinance, Chapter 109. This will go up to page 115 of the motto copy in Chinese. As it is a principal ordinance, Chapter 109, we will make technical amendments to accommodate the regulatory framework for TSW. We will also remove some provisions on GETS. And for Clause 66, we will amend Section 2 to repeal certain definitions. We will also repeal subsection 5 on GETS and agents of GETS.
And we will also add in the definition of specified system has the meaning given by Section 2 of the Import and Export Ordinance, Cap 60. Part A, like the INEO ordinance, Clause 67, we will be repealing Part 1A, including Section 3A, Section 3B, and Section 3C. These provisions are related to the use of GETS, and these are not applicable to the to TSW, and these will come into operation on a date to be appointed by the Commissioner of Excise, Customs and Excise by notice in the Gazette. And Section 22, right now the carriers are required to lodge a declaration within 40 days to state whether they are carrying dutiable commodities, and the carriers under the regulations must furnish the cargo manifests, and the details should be set out, and the carrier is deemed as complying with the relevant statement. Clause 68 amends Section 22 of the Dutiable Commodities Ordinance, allowing the trade to lodge the statement pre-shipment, and the specified body is no longer applicable. Page 127. We will add in Section 52C to provide some transitional arrangements, and the Commission, by publishing a notice in the Gazette, specified a date on the cessation of the transitional period. Part 9. We have to add in a new part 9 covering sections 75 to sections 80 to set our legal framework for the information transmitted by the VASP. And these are tally with the relevant provisions in the section governing the value-added service providers. And then we come to Schedule 1A and Schedule 1B. The DCO also set out the specified electronic service providers and specified eligible agents. So these will come into force on a date to be gazetted by the Commissioner by way of a notice in the Gazette. We will repeal these schedules. And page 136, Cap 109 subsidiary legislation A, and clauses 73, 74, and 75. These we are amending relevant provisions related to gas, and we are using the specified system as a term and considering the nature of dutiable commodities and the relevant limitations and under the regulations. There will not be any transitional arrangement. These will be handled directly and immediately under the TSW. So there is no need to add in the relevant transitional provisions. And these provisions will come into operation on a date to be appointed by the Commissioner by notice in a Gazette. And these will come into operation on a date when the TSW is implemented, and that will be in the second half of 2027. And then let's move on to page 141. Reserved Commodities Ordinance, Cap 296. These regulate reserved commodities, including rice. These also contain legal provisions related to gas, so we will be making the corresponding technical amendments to add in the relevant TSW legal framework and repeal the provisions related to gas. We will make technical amendments to Section 2, repealing all the interpretations and definitions related to gas, and we will also repeal the schedules related to gas service providers, and we would also be adding in the definitions related to the VA value-added service providers. We will repeal 2A, 2B, and 2C, like amendments in other legislations. We will repeal these three sections related to gas, and they will come into operation on a date to be gazetted, to be appointed by the Commissioner by way of a notice published in the Gazette. Okay, maybe I will pause here. We still have 10 more minutes. Maybe there isn't much left to work on, so shall we try to finish the scrutiny today? Cap 296A, Subsidiary Legislation A, Part 5. These are related to return of licenses. Like Cap 61, we will make the corresponding amendments. And legal advisor. Clause 678 and page 147 of the marked up copy. And you haven't really gone through certain parts in the marked up copy. Page 147, these are also technical amendments. So the specified system will substitute services provided by a specified body. And again, Section 15 is also a technical amendment. 16, Section 16. We would like to add in a provision stating that the Commissioner may issue practice guidelines. And these are related or similar to the provisions earlier on in relation to the VASP. And let's move on to Schedule 1 and Schedule 2. These are legal frameworks related to gas, so we suggest repealing Schedule 1 and 2. And page 156, Division 5, and Cap 296 Subsidiary Legislation A, that is related to the return of licenses. And like CAP 60, we are making a similar amendments here. So these are also related to the return of licenses. The transitional provisions under 26 will be repealed, and we will add in a new section 26, which is related to our present case, and the amendment is similar to the previous amendments. And CAP 316 Industrial Training Clothing Industry Ordinance. These are, again, technical amendments, and the legal frameworks related to gas will be repealed, and we will add in definition relating to specified system. And then again, technical amendments thereafter. And we would also add in a pre-shipment export declaration definition. There is this additional option provided if pre-shipment declaration is made, or there is also the requirement on updating the relevant information. And the requirement is similar to CAP 60. And Section 24, again, technical amendment. Section 25, technical amendment, substituting services provided by a specified body with a specified system. Part 5A, page 174. We are adding in the legal frameworks related to value-added service providers, and these provisions are similar to those in CAP 60. And then we come to page 178. And security device, duty of specified agent. Since these are related to gas, we suggest that these sections be repealed. And hereafter, again, technical amendments, 33A, we are adding in a similar section in CAP 60, reasonable excuse. And technical amendments, again, 37, we have to add in transitional provisions. If members agree, then I will extend the meeting by 15 minutes. I believe that we'll be able to finish the scrutiny. At page 185 is the protection of non-government certificates of origin ordinance, CAP 324. We are also doing away with definitions which are no longer applicable, such as security devices, specified agents, and so on. And we are adding in new definitions. Frameworks related to gas are again repealed. And then following are some technical amendments. Section 4, subsection 3, there is an option provided to non-government bodies issuing certificates of origin. They are given the option to issue certificate of origins of re-exports by way of an electronic means. So this is an option provided to them. And then again, specified system, replacing services provided by a specified body. 6B and 6C are frameworks related to gas. These will be repealed. Section 8, again, technical amendment. Section 11A, page 195. Commissioner may issue practice guidelines. These are similar to the frameworks for the VASPs. Page 199, we have added in a new section of 14, transitional and saving provisions, which are similar to those under Cap 60. Thank you. Selina. So we are finished with the clause-by-clause scrutiny. And the administration, please see when you will respond to the legal advisor's written queries. And after that is done, can the legal advisor ascertain whether the English rendition is proper? And if members would like to move an amendment to the bill, I would like to set a deadline. Can we do it by the 8th of May? You should do it. You should do it in writing. And if the administration would like to move amendments, please do so as quickly as possible. So we're basically done with the scrutiny work. And if there is a need to hold another meeting, the secretary would notify everyone. So AOB? If no AOB, meeting adjourned.